everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So today we have an editorial that will be discussing about the clubbing and merging of the cases, which has been actually denied by the Supreme Court in the case of Nupur Sharma. The Nupur Sharma and the hate speech case we already have discussed, so I hope that you already are through with it. Then we have the news update and legal news for ourselves. So basically, this article talks about law and precedent of clubbing of cases and the Supreme Court's denial of Nupur Sharma in this particular case. So recently, the Supreme Court denied the plea of Nupur Sharma, who was also the spokesperson of BJP. Before, we all know that she had given some alleged derogatory remarks on Islam and some, remarks of intolerance. And that is why the Supreme Court has denied the clubbing of such hate speech cases that had been filed against her across the country. So Nupur Sharma was directed to report to individual high courts, and generally there is clubbing of cases that is done, but in this case it was denied so, and her actions were called out as irresponsible, and she was also termed as single-handedly responsible for the outburst in the country, which is actually a major thing to say. So let's see, what do we hold in future for Nupur Sharma. So let's see that why the clubbing of cases and why Supreme Court has denied in this particular case. So we know that a person cannot be prosecuted for the same offense more than once. And this, we all know, is a fundamental right under Article 20 Clause 2. And this is called as the rule of double jeopardy, rule against double jeopardy, basically, in which if we know that a person has been prosecuted once for a particular offense, so that person cannot be prosecuted again for the very same offense. Here, guys, please note that there is always an exception when it comes to Article 20 Clause 2. It talks about the prosecution in the court of law. But any kind of disciplinary action that is taken by the department or any institution, that is, it not considered to be as a double jeopardy. So please consider it over here. Then it says that in the case of T.D. Anthony versus State of Kerala, the Supreme Court held that there could not be a second FIR for the same issue, because obviously, if second FIR for a particular issue would be allowed, there would be, what we'll say, doubling of the FIRs, and a great confusion can be created. And this was further expanded in the case of Arnab Goswami case, which took place in 2020. But in this case, the Supreme Court held that Nupur Sharma could not be given the same treatment as she was a political spokesperson. And guys, we know that just because, for example, you must know that a person who is kept as a guarder, as a safeguarder of a particular thing, and that person steals a thing, so there is an aggravated punishment for the person. Similarly, when it comes to the political spokesperson or people who are into public figure or who are a public figure, if they propagate ideas of hatred or intolerance, definitely it is definitely frowned upon as compared to a normal person who is not a public figure. And that is why the Supreme Court has held that Nupur Sharma could not be given the same treatment as normal ones, since she is a political spokesperson, and hence the Arnab Goswami ruling did not apply on this, and that is why the clubbing of cases has been denied by the Supreme Court for Nupur Sharma's case. So the Supreme Court also held that if the conscience of the court was not satisfied, then the law could be molded for the best as well. So let's see, what do we have for news updates today? Firstly, T. Rajakumar has taken the charge as the FATF president. So Indian origin Rajakumar will now focus on enhancing the effectiveness of the global anti-money laundering and counter-terrorist financing measures under the FATF, which is the Financial Action Task Force. Now here is a small task for you all. Pause this video right now and let me know if India is a member of the FATF or not. Secondly, Yair Lapid is now the new Prime Minister of Israel. So Yair Lapid officially became the 14th Prime Minister of Israel at the stroke of midnight on 2nd July. So Lapid's term could be short one, as he took over, or he has taken over as the caretaker government ahead of Israel's election, which was scheduled to take place on November 1st, and the Times of Israel has reported this particular thing. Here is another question for you all. If you all can tell me that there is a place which is situated geographically into Israel only, or geographically it is there in Israel, but there is a great ethnical, conflict that is there between Israel. You must have heard Israel-issue. If you know the name of this place, let me know, guys. Thirdly, Neeraj Chopra won silver in Diamond League, which is a very, a moment to be proud for all of us. So in the Diamond League played in the Stockholm, Neeraj threw 89.94 meters. While doing so, he broke his own national record, which was made on June 14th. So Neeraj won a silver medal in Pave Nurmi games in Turku by throwing the javelin 89.30 meters away. Let's see what do we have for the legal updates today. Firstly, IBC does not protect the interest or claim of partner against another partner or the firm, says the NCLT Mumbai, which is the National Company Law Tribunal. So the National Company Law Tribunal bench has held that the IBC, that is the Insolvency and Bankruptcy Code of 2016, does not protect the interest or claim of a partner against another partner or the partnership firm. So this was held in the case of Parul A. Vora versus Kavya Buildcon Private Limited. Secondly, can't refer dispute to arbitration unless there is a clear, unequivocal denial of a right, says the High Court of Kerala. And this was held in the case of Southern Railway versus Messrs. Cherian Varkey Construction Company Private Limited. So the Kerala High Court has held that the cause of action giving a party the right to refer a dispute to arbitration only accrues when there is a clear and unequivocal denial of a right by one party by the other. So this was all for today. We hope you liked this session. You can download the PDF of today's slides from our Telegram channel. The link is there in the description box below. Or you can also scan this QR code that you can see on your screens right now. Thank you so much for staying with us.